Okay, hi everyone. My name is Maja Sahajic. I am a co-chair of the ICONAS New Directions Committee. And today with me I have Hanna Birkenkotter and I have Dana Burchardt, both fine researchers who are going to, and professors who are going to present their latest book on the rule of law in Germany, bringing the Rechtsstaat into the 21st century. Let me tell you a few things about Dana and Hannah. Well, first of all, I made some notes, of course. Dana is currently a visiting professor at the University of Bremen, and she's also an associated researcher at the Max Planck Institute for Research on Collective Goods in Bonn. Previously, she was working at Humboldt University in Berlin, but also at the Free University of Berlin in the context of the interdisciplinary Berlin-Potsdam Research Group, International Rule of Law, Rise or Decline. She was also an assistant professor at the China University of Political Science and Law and the senior research fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg. When it comes to Hannah is currently an assistant professor of international law at the Autonomic Technological Institute. I'm translating from Spanish of Mexico, in Mexico City, of course, in Mexico then. And prior to joining this institution, she was also postdoctoral Emile Noel Fellow at the NYU School of Law in the US, and also a research fellow at the law faculty of Humboldt University Berlin, where she also remains an associate researcher. She's also an associate editor of the Verfassungsblog, and so on. I had to cut down their bios because they're very long and very rich. But I will move on to the book because we do not have that much time. The book itself, the book that we're going to talk about today, that we're going to present today, is actually about the extent of the rule of law in Germany, and to what extent, actually, the question is to what extent the rule of law has translated into a reality for all in Germany. The chapters in this book explore not only the history, but also the doctrine of the rule of law and the challenges to the rule of law in today's Germany, and also the rule of law experience in the former German Democratic Republic, and of course in the context of reunification, the relationship of the German rule of law practice with the rule of law on the European and international level, but also the rule of law in times of crisis. My first question to both of you, first, welcome both of you to this presentation on our YouTube channel, but also to our podcast. My first question to you, maybe Hannah, is how would you describe, before we go into the details of the book, how would you describe the state of the field of comparative public law or comparative constitutionalism today, and how do you think it has changed lately?
Yes, first of all, thank you so much, Maya, and to all of the ICONS team, and especially the New Scholarship Committee, for giving us the chance to present our work here. I think it's a great question because I remember when I took comparative law as a university course, it was actually comparative private law. So the very field has emerged from when I was a student to today. And I perceive it today as a very active field with very many cross-border collaborations that actually has geographically expanded, I believe. It is not now centered on a few states as perhaps used to be. It's more diverse in terms of geographical representation. But I think there's also been, especially perhaps in the past 5 to 10 years, been like a substantive shift. So we are more open, I believe, now to questions of law and society. Methodologically, we include legal historical dimensions, sociological dimensions in our work. And I believe that the book, in fact, it's part of a series that's called The Rule of Law in Context, is a testimony to that shift as well.
Um, I think you mentioned two keywords here in your answer, and I think one of those is geographic shift, and the other one is methodological shift. Maybe I can connect it to the second question, and the second question would be about your scholarship and how it has evolved over time. What has driven that evolution, and can we also see this shift actually in your book as such? I think this would be maybe for Dana.
Yeah, thanks for this question. And also, of course, for me, thank you for having us here in this format. Yeah, so actually, you're right. That is actually these two first questions actually connect very well together because I think both Hannah's and my research does reflect that shift in the overall field as well. So, for example, what is representative, I guess, for both of our research is that we have focused more strongly in recent years on an interdisciplinary perspective. For me, that is especially due because to the fact that I've been involved into several interdisciplinary research groups and research settings, so that has kind of fostered that move a little bit. But then also, as to the geographical shift, that is also something that has been very important for my comparative research. When I was starting out, I initially had more of a European-centric focus in my research, and that has broadened much more in recent years. I also try to sort of say switch the perspective in a comparative work that included a comparison with the African context. I try to sort of say not start off from the European perspective and compare it to the African perspective, but the other way around, so to say. So that is something that I found very interesting as well in terms of comparative outcome that one might have. And then I think for Hannah, I think another aspect would also be that in terms of the shift over time to to broaden our initial field. So for Hannah, it would be international law more prominently towards also and connecting it also to the comparative and the constitutional law aspect. So basically this intradisciplinary kind of dialogue between the different subfields of law that one can make stronger in your own research as well.
What I hear here, and also as somebody who does interdisciplinary comparative work and so on, I'm fascinated because you're mentioning interdisciplinary perspective and combining international constitutional law and so on comparatively. But you also mentioned something along the lines of decolonizing the knowledge because you mentioned the global south and moving or shifting from the European centric type of approach towards other geographic areas and so on. Was that a logical evolvement for you, or maybe even better, how does that actually build upon, or how that fits in to your existing scholarship? I think that would be maybe a logical follow-up question on this. Maybe Hannah, you can take over.
Yeah, thanks. So I think what Dana mentioned is really important because I think it shows how we complemented each other as authors of this book. So I had worked previously mostly on public international law. I had done work on the rule of law in the United Nations. And in that context, this was my doctoral dissertation. I had done some policy work. So I was, for several years, a board member of the UN Association in Germany, and I'd done some work on the rule of law and German foreign policy, German foreign relations. So this book kind of like is a continuation in that it broadens my rule of law work to a domestic context, which had not initially been my focus. For Dana, she had done quite a bit of work on rule of law related issues, especially on judicial independence and fair trial guarantees, which is a very prominent part of our book, but also on the work on the interaction between European and domestic legal standards. And so we have one chapter in the book where we look at the European and international entanglement of German rule of law um, scholarship and thinking about the rule of law today, which we both believe is not currently very prominent in German doctrinal research on the rule of law. So we believe that this is, in a way, bringing both of our prior research together in this book and complementing each other.
This prompted me actually to have another follow-up question, to zoom out a little bit. What you mentioned, both of you, we focus so far on something internal, so something internal in terms of what you do, how you do it, and so on. But if we zoom out from the external perspective, and especially when you say something about non-prominent aspects in German scholarship and so on. So if we zoom out, what would you say, what line of scholarship does the book build upon externally? And how does it actually differ from some existing or competing accounts? Dana?
Yeah, thanks. So yeah, that it does, of course, build, as Hannah said, on our own previous work, but in terms of other work, it builds depending on the issue areas that we cover on various things. So the first thing would be, especially for the first chapter of the book, on the doctrinal constitutional law engagement in the German literature on the rule of law as a constitutional principle. So the Rechtsstaatsprinzip in German, so this principle, how it developed and what its content is. So this is obviously at the core of the constitutional law debate, so to say, on this notion. But then also, you already mentioned in the introduction of the book, we cover a lot of specific issue areas, so to say, in relation to the rule of law in the book. And we then relate to the various scholarly contributions with regard to that, be it in the context of counterterrorism measures, or in the context of digitalization, or in the context of judicial independence and so on. So these specific issue areas, of course, relate to the existing literature. And then as a third, so to say, inspiration or a point of linkage, so to say, for the book is the fact that this, as both of you have already mentioned, that this book is part of this book series, The Rule of Law in Context. And we there were some volumes that have been published already before we started the work on our volume. So we try to also have a dialogue with these sorts of, so with the other volumes. And for example, one aspect that we included specifically with this notion or with this idea in mind to have this dialogue was the question of inequality as an aspect of the rule of law. So that is something that was very prominent in some of the other volumes, and that we wanted to therefore also include, so that we have a little bit of a, so to say, a comparison also amongst these different volumes within the series. And then you asked also not just what we build on in our scholarship or in this book specifically, but also how it differs from other work. And here, I think, again, I can refer to this book series, which has a very particular focus. So it's the rule of law in context, which means really to look at the lived experience of the rule of law in the different countries. So that goes beyond the classical doctrinal or legal formalistic, so to say, analysis of issues of the rule of law, but really to look how it's being perceived by different actors, by different groups within the society, how it's experienced, how the rule of law is practiced in Germany. So that is, I think, what makes this series and also then our book stand out, because especially also with regard to the German existing scholarship on the rule of law, this is something that is not really haven't been there before. So that this is something that I think we bring both to the international debate on the rule of law, the comparative debate, so to say, but also to our domestic debate on the rule of law in Germany.
I think you already circled back to the beginning to a small introduction that I made about your book, but you also opened up, I think, some of the topics, or you mentioned some of the topics that are being discussed in your book. It's somewhere, maybe fourth or fifth question or a couple questions into this conversation, and only now I ask what are the main claims in her book. But I think it was necessary actually to set a broader scene to actually understand where do you come from and how do we now discuss those main claims. So maybe Hannah, do you want to tell us more about the main claims advanced in the book?
Yeah, sure. So we believe, and this also comes from the title, bringing the Rechtsstaat into the 21st century. The Rechtsstaatsprinzip, the rule of law principle, really is, in the self-perception of German constitutional law, a foundational principle. So it's foundational for German constitutional law as a discipline. It is considered one of the most important principles of the Constitution. It has been there for a long time, so it dates back to the 19th century. And so there is a long history and tradition of the rule of law in German constitutional law's self-perception and self-understanding. But, and this is what we show in our book, and this is what Dana also mentioned already, it has really fallen short to translate into really a lived experience for all. So we see that with regard to substantive equality, where we also draw these comparisons to the other volumes in the series. But then there are also some areas that we believe might actually be surprising for international readers, because beyond this being a self-perception of German constitutional law, I believe German constitutional lawyers and also other parts of like other German actors have been relatively successful in bringing this vision to the international community that Germany is a rule of law state. But there are some issues, in fact, that are more traditionally related to the rule of law or associated with the rule of law, where Germany has not always observed its own rule of law principles. So we mention a couple of cases of non-observance of court judgments, which is always a classic of rule of law doctrine. So another point that I believe perhaps people might not even be so aware of are the appointment procedures of general prosecutors that are not independent to a measure, as is the case in other countries. So there are some sort of like classical institutional rule of law dimensions where, again, one might question how that compares to other countries in the region, to European standards, to the international debate of the rule of law. Then the other main claim that we advance or that we show in the book is that really Germany comes with a history of authoritarian regimes, and that's puzzling if you think about the simultaneous idea of being a rule of law state. But from the authoritarian regimes in Germany's past, both the Third Reich and the German Democratic Republic, there is this very thick variant of the rule of law, a substantive understanding of the rule of law that is today prevalent in German constitutional doctrine and constitutional theory. So we have a very strong focus on fundamental rights protection, on human dignity as a part of our rule of law understanding today. But at the same time, and this is where sort of like the first point comes in again, the rule of law today is also intrinsically connected to European and international rule of law debates. And so, for example, the appointment procedures of general prosecutors is something that came to the fore through through entanglement of Germany in a European context. And so this is something that wouldn't have become an issue, we believe, in Germany without the European level that is today part and parcel of how we understand the rule of law. And so these would probably be sort of like three main claims that we might advance. And then we have the last chapter. Maybe Dana wants to say a little bit more about that because this is her area of expertise that looks a little bit into the future and says, well, the rule of law also so there are new challenges for the rule of law, and digitalization is perhaps one of the clearest challenges on how we might want to think about the rule of law going forward.
It is a complex topic. We touched upon, from what you deliver in your answer, it is obvious that there is a lot of complexity. We touched already upon, geographic shifts, but we also said something about methodological approaches or choices, actually, that you had to make or that you made in order to make this work. I want to expand a little bit more on that, because I think that is very important, especially when it comes to legal methodology and the choices that we are confronted with, especially when there is a complexity of this kind. So maybe Dana, maybe you can tell us a little bit more about the methodological approach that you took in this book to actually work your way through towards the end, towards wrapping everything nicely together.
Yeah. So the starting point for the question of what methodology we would use was, of course, again, this approach of assessing the rule of law in context, assessing the lived experience of the rule of law. And we thought it would be useful to combine different approaches. So, of course, as we have already hinted at, the basis was a doctrinal engagement with the rule of law on the specific issues related to the rule of law. That would be the first methodological stance, so to say, that we have included into the work on this book. The second one would be a historic perspective. So that, I think, is really important. Hannah hinted at it a little bit already, to understand both the concept of the rule of law on a conceptual level, so to say, but also the experience of the rule of law. So this includes, for example, just the tracing of the development of this notion of Rechtsstaat, of rule of law in Germany, and the development, as Hannah said, towards a rather thick understanding of the rule of law, substantive understanding of the rule of law, which we show in the first chapter. But then also to engage with certain very prominent events and periods in the history, so to say, of the rule of law practice in Germany. So one example with regard to the crisis chapter would be the 1970s, which were very, very prominent, or which had a very prominent practice and debate around counter-terror measures, because there was a peak, so to say, of the left-wing terrorism at the time in Germany, and there were very draconic countermeasures of the German state against that, and the discussion at the time and later on, and the so to say consequence that would have had on the long run, that would be one of the historic elements that we would include in our engagement with these specific issue areas. And then a very important historical aspect is as well our chapter on the rule of law experience in the GDR and in the context of German reunification, because we think that's something that is very unique, so to say, to the rule of law experience. Not many, if any, countries would have a similar experience in relation to the rule of law, and we show, so to say, the challenges that especially reunification also posed on various levels to rule of law standards. And when it comes to engaging with the rule of law in the GDR, the idea was also to be, so to say, inclusive in terms of reflecting the rule of law practice of all Germans, not just, so to say, the West German experience. So that would be another very important point. And then as a third perspective in terms of methodology, it was important for us to also assess the rule of law discourse. That is the way the notion of the rule of law, of Rechtsstaatsprinzip, is used both in the legal debate, but also in the social and political debate. We show how in certain instances it is used, it is criticized, or so to say, there is talk about challenges to the rule of law, risks to the rule of law, which are in some instances justified to have a proper factual and legal basis, so to say. But in other instances, there's a lot of misuse as well of this concept. It's being used for political purposes. There's claims of the rule of law being in danger, but in fact, what is behind that is just other political considerations and ways of discussion, so to say. So that was another aspect that we wanted to really highlight in terms of showing how rule of law comes to life, how it's practically experienced in Germany and for the people who live here.
And while unpacking all of these questions that you had in front of you, what was the most challenging in this research writing process that you experienced, Hannah?
Yeah, I feel like there are like two dimensions to it. So one is, of course, just like as a practical matter, we were in different time zones. I was in Mexico City, Dana was in Germany. We had to coordinate. I was also starting a new job. Dana was finishing her habilitation, so it's always was challenging to coordinate the process, but that was well for me specifically. I noticed how difficult it is to access a lot of German resources from abroad. So Germany has gotten better, I believe, in part due to the pandemic, in providing access to literature, but there was quite a bit where Dana was really sort of like necessary in order to procure parts of the literature, because there are some handbooks that are simply not available online, but that are important in the German literature. But then substantively, I believe really perhaps the most challenging part was to convey a very long and a very complex debate. And not only one debate, I mean, as Dana mentioned, we have these different dimensions to the book, and they all come with their own literature, and most of it is in German. And so to convey these different strands of the debate, the doctrinal dimensions, but also the debate on other topics that are related to the rule of law, to an English-speaking public in a somewhat accessible manner, I believe was quite challenging, because that also involved the translation, like the literal translation of some key constitutional concepts, constitutional legal concepts from the German language. And it's not always obvious how one would translate certain concepts. Like, to give you an example, in as part of like sort of like traditional part of the German rule of law doctrine is this idea of the primacy of law and public acts that need to be grounded in statutory law. And that is a very bulky English expression that I just used, but is the best that we could come up for what in German are 6 words, which are Vorbehalt des Gesetzes and Vorrang des Gesetzes. Vorrang meaning primacy, so that is the simpler one. But this Vorbehalt des Gesetzes, the idea that public acts need to be grounded in law, really is sort of like was difficult to translate. And so that was, I believe, one of the larger challenges, substantively speaking.
But I'm sure there were some rewarding parts of your research or your writing process. Maybe you want to share that as well, Hannah?
So one thing that was very
Or
rewarding,
Dana, or Dana.
yeah, so
Yeah, sure. Yeah, so actually it kind of connects a little bit to what Hannah says, because for me, what was challenging also led to something that was really rewarding and fascinating, which is to be able to design and structure a book that combines various things, that goes beyond the classical approach to how the rule of law is being discussed in Germany. So that means, like, as Hannah said, figuring out which would be the most important key terms and key topics that we would want to include in the book, but also to think what would be most interesting and insightful, so to say, for an international audience and readership. That is something that I found really interesting to reflect about. And lastly, to also cover some aspects of what we think are important parts of the rule of law, which are not discussed as much in the German debate. So, for example, this chapter that I just mentioned, the GDR and the reunification context, this is something that is pretty much not discussed at all. Hannah also mentioned the this interlinkage between the European and international level and the domestic level with regard to the rule of law debate. Also, that is not very prominent at all in the debate in Germany. So it was really interesting, really, to also use that book to shed some light on some aspects of the rule of law that might be more prominent in other countries, or the discourse that happens in other countries around the rule of law, but is not that central so far in Germany. So that I found very rewarding.
Well, I want to finish on this positive note, on those rewarding, parts or something that made you feel good while you were working on the book. And maybe my last question, building upon that, what's next? What are you working on right now? Maybe both of you can actually address this question.
Yeah, so I continue to work on the rule of law. I have a book project on the rule of law in the UN that's currently under review. So let's see how that goes. And then building on that, a topic that I find interesting and that I'm actually working on right now, I work a lot on international organizations law, especially the UN, and I am interested in the different actors that participate in international lawmaking processes, in the legitimacy of international lawmaking today with a multiplicity of actors. And that also brings in this dimension, sort of like of connecting international law to constitutional law, and to see how domestic and international law intersect, because a lot of the multiplicity of actors comes from a closer connection, I believe, between domestic and international law. So those are two, it's like a topic and a specific project that I'm working on right now.
Amazing and promising at the same time. Dana?
Yeah, so for me, I also continue working on the rule of law or certain issues related to that. One is a broader long-term project on procedural guarantees, but in the transnational context, a special perspective on that. And another second, so to say, set of projects relates to rule of law related issues in the context of artificial intelligence. So this digitalization aspect that is also part of the book will be continued in this way in my further research as well.
Something I also work on as well. So let's see if there is a connection. On that note, I will end this conversation. I will first thank you for your time, for agreeing to actually share all of those fascinating details, and for walking us through all of these research questions, methodology, and also the content of your book. And if you wish, you can actually say some last words.
Well, perhaps really thank you. Thanks for having us here. So this has been a great opportunity to also be able to share some of the ideas of the book to a wider audience. Obviously, if you are interested in our work, reach out to us. And well, ICON really is a great space, I believe, for this kind of research. And perhaps circling back to the very first question, one of the places that has brought comparative public law to where it is today, including these interdisciplinary dimensions and intradisciplinary dimensions.
Thank you so much. You said it very, very nicely. That is actually
I can also just so second what Hannah said, and thank you again for giving us this opportunity and engaging with our book. So thank you very much.
Thank you so much, and hopefully till the next time.
Thanks.